and offering my respect to the First Canadians, custodians of the land where our offices stand. We're joining you from Meanjin in Brisbane today, and where we all work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits, and we recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and in improving our justice system. So welcome to today's webinar. Today's topic is NDIS Appeals Explained, Understanding the Process and Your Client's Rights. I'll introduce myself first. My name is Catherine Gorta. I'm the Community Legal Education Coordinator here at Legal Aid Queensland, and I'm joined by Lana Bellingham-Young, who's a civil lawyer in our NDIS appeal team, which is part of our Civil Justice Services division here at Legal Aid. Thank you for being here today. Before we kick off with today's content, we've got a little bit of housekeeping to run through with you all. So firstly, this webinar is being recorded and the laws and content are accurate as of today, and they're subject to change. There's further information about all of our community legal education resources that we have at Legal Aid on our Legal Aid Queensland website. If you have any technical issues today with your webinar sound, you will need to contact GoToWebinar customer support for that help. Unfortunately, we can't offer that help during the live webinar. So it's a 1 hour webinar today. We've got probably about 40 minutes of content time, plus we're allowing plenty of time for questions. If you do have any questions for Lana during the webinar, please type them in the questions box. We'll take a look at those and bring them up during the webinar. There'll also be a Q&A session at the end of the content, so please feel free to type in some questions for that time too. There will be a copy of the slides available to be downloaded in the handout section on your screen, so if you want a copy of those, please download them. We'll also send a copy out with a link to the webinar recording after this webinar. We'll also be preparing a separate handout with some key takeaways from today's webinar for you as well, so look out for that one in the email. We're going to kick off with a couple of polls just to find out a bit more about who's joining us today. I'm just going to launch the first poll for you. So the first question is, which region do you work in? And the options are South East Queensland, Far North Queensland, Regional Queensland, or outside of Queensland. I'll just give everyone about 10 seconds to pop their answer in there. Couple more seconds, and I'll just share those results. So we've got about 44% from South East Queensland. We do have to have 38% from outside of Queensland. So what does that mean in terms of the content for people outside of Queensland?
Beyond what supports Legal Aid Queensland can directly provide you, it all should be applicable to your work because it's a federal jurisdiction, so it all should be fairly applicable.
Fantastic, thank you. And also welcome to people joining us from Regional and Far North Queensland as well. All right, moving on to our next poll. What is your role? I'll just launch that one for you. So the answer options are community worker, support worker or social worker, allied health provider, disability advocate, NDIS participant or applicant, or other. Now this will be really helpful information for us just to know who's joining us today and if we can tailor any of the content to you. So thank you for sharing this with us. Just a couple more seconds and we'll share the results. Okay, I'll close that off and share. So we've got 34% other. I look forward to seeing what all those roles are after the session. Our other big group is disability advocates, so thank you and welcome to the webinar today. We've also got community workers, support workers and social workers at about 16%, and great to also have some allied health providers and NDIS participants or applicants with us today, so thank you so much everyone. Moving on to the next slide. So just a quick run through of what you will learn in today's webinar. So we'll be looking at how the NDIS functions and defines terms, changes to the NDIS Act and how this affects participant supports, what evidence is needed to gain access to the NDIS and what evidence is required to get supports funded, And I'll hand over to Lana now. Thank you.
Hi everyone, thank you for coming today. Hopefully it's an informative session for you all. So I'll be running through this a little quickly because there is a lot of content to go over, but like Catherine mentioned, we'll be providing an additional handout as well that have a bit more detail and some, hopefully a few resources that you can look on to help you in the future in terms of getting evidence and providing evidence. So just briefly, I wanted to just talk about how the NDIS functions and in terms of how it's structured, why it has the structure it has, and what needs to be considered when you're like making recommendations or things like that. Effectively, everything operates under the National Disability Insurance Scheme. When you're interpreting that, that also needs to be considered with in relation to the NDIS rules and some transitional rules, some determinations made by the relevant disability minister. And the NDIA also publishes some operational guidelines which need to be considered as well. In terms of the guidelines, it's important to note that where the guidelines don't inherently match up with what the legislation's saying, it's possible that those will not be as strong as a supporting argument as a legislation would, but typically they are accepted by the tribunal and the decision makers to be something that needs to be considered. All right. So in terms of general information and general way that decisions are made in the NDIS, decisions are made on what's called a merits review basis. So what it will be is they'll have a look at the specific criteria, either that be, for example, if you're trying to get access to the scheme, so like the disability requirements, or you're trying to get support funding change, or your client is the reasonable necessary criteria. Those criteria come from the Act. And in order to make a decision as to whether or not that criteria has been satisfied, the decision maker, whether it be the NDIA itself or tribunal at another stage, needs to have sufficient evidence to be satisfied that the criteria has been met. So in terms of who needs to provide this evidence, in most occasions, it'll be the applicant or the participant who needs to provide that information and that evidence. And there are some minor circumstances where you can kind of ask the agency to also prove themselves, but that tends to be more at a tribunal level as opposed to your kind of normal interactions with the agency. Okay. So in terms of obtaining and providing evidence, the main thing I want to kind of get through today is the evidence really needs to very clearly set out why a recommendation has been made or why this opinion's been formed. And the reason that is back to that kind of merit assessment process, is that they have to look through a very specific criteria, which may not align with how assessments happen in like allied health field or clinical or otherwise. So they need the very clear information so that they can make that determination that a criteria has been met, as opposed to relying purely on an opinion or a recommendation. So sometimes you'll see for access cases, a doctor will write, this condition is permanent, it's been treated, and that's kind of all the letter will say. And the NDI don't tend to accept that, and it does cause a bit of frustration for the participant, obviously, or the applicant rather. But the reason that is because there's not sufficient information for them to be satisfied under their criteria for permanency that it's been met. So very much more information is better. The way I think about it, I often say is it's like high school math. You get 1 point for the answer, but you really need to show you're working. So that's my key message for today. Okay, so I'm going to first talk about accessing the NDIS. So to access the NDIS, there's first you have to meet age and location requirements. Those are fairly easy. Have to apply before the age of 65 and have to be Australian resident. Once you meet those two, you can either gain access to the NDIS through meeting either the disability requirements or the early intervention requirements. It's possible to meet both because it's focused on a person's impairments and which one meets which, but typically it'd be one or the other. So I've provided kind of the general summary of what the requirements are for each one of them. I'll go into a bit more detail now. I think this is important to understand in terms of going into what we're going to talk about in a second. A lot of terms in the NDIS have a very different meaning to what you would typically understand outside the NDIS. So that often causes issues with reports where there's a focus on condition, but the NDIS is looking at what their impairments, not the condition. So that can cause a bit of confusion. So in terms of disability in the NDIS, a disability is formed by one or more impairments. That is what a disability is in terms of the NDIS kind of sphere. Disabilities and impairments are not a person's diagnosed conditions as well. There's a very clear distinction. When you're considering what an impairment is, that is the way in which someone's condition, or not even if it's diagnosed, but the way in which someone's functional capacity is affected, which forms the impairment. And within the NDIS, those are categorized as intellectual, cognitive, neurological, sensory, or physical impairments, or are collated as impairments which form what's called a psychosocial disability. So the other one thing to note is, while someone may have a permanent condition, it's possible that they don't have a permanent impairment. So say someone has broken their leg and they'll have a fracture in there or something like that, or like EDS, for example, consistent injuries. That condition is permanent, but it's potential that the impairment they're having from that injury at that time is not permanent, and there's treatments that could be done to remedy that. The test for permanency is that an impairment is permanent only if there are no known, available, and appropriate evidence-based clinical, medical, or other treatments that would be likely to remedy the impairment. So I'm going to get into a bit more detail now. So for both early intervention and the disability requirements, you're going to need to establish that impairments and the permanent impairments. Unless they're under the age of 6 and they have a global developmental delay. That is the only exception for early intervention. The first step I always say is, with the evidence you're getting, identify what impairments a person has and where those have been formed from, whether it's a condition or a different like injury or something like that, like what is actually forming that impairment. Then once you've done that, then the step goes on to, okay, is that impairment treatable? So typically you'll need evidence from treatment providers, or if that's not able to be accessed, sometimes you can obtain medical records and things like that of prior treatments. The next bit. Back to kind of that kind of concept of what are the actual impairments in the NDIS. I've just included this slide. I won't go into too much detail on it, but this is how they categorize impairments under the NDIS. So this doesn't always align with what you'd usually see in other assessment kind of things. So it's not strict, but it is a good thing to keep in the back of your mind, as this is what the NDIA is considering are impairments based on the conditions or multiple conditions that someone has. What are the impairments that are forming and how do they get categorized in here? So back to that test for permanency impairments. This one is a difficult one to establish. It often is one of the first, it is kind of the first big criteria that people have struggled to overcome. And the main reason I see is just a lack of clarity in the evidence they're providing, and also just a lack of evidence in general. Going back to that reliance on a letter that says, yes, the condition's permanent, that is not enough to meet these kind of elements that you need to be establishing. So effectively, to confirm that there's no further treatments, you need to establish that they've undergone previous treatments, kind of what the base recommendations are for someone in a similar condition or impairments that they have. Of those kind of treatments, what are appropriate for that applicant to undergo, and if it's not appropriate, why not? When we're talking about appropriateness, that refers to things like, do they have any other pre-existing medical conditions or any other factors that would prohibit them from undergoing that treatment? And that can be like allergens to medication or having really negative side effects to that treatment. So those things should be considered, but they also really need to be clearly outlined in the evidence. Of those treatments that are appropriate, the next question is, which ones are actually available to the client? So when we're talking about availability, things like geographic limitations can be applicable. There's also the consideration of, is it in the public health system or not? And there's been, case law is kind of conflicting in terms of cost. Typically not being able to afford a treatment but it is in the public system isn't sufficient. So if you can, in theory, access that treatment in the public system, then they'll consider that there's further treatments that person could do. In saying that, having a look at what treatments haven't been done or what's outstanding, the question still remains, would those treatments or engaging in those treatments, would that be likely to remedy the impairment, again, not the condition, but the impairment for that person? And in this context, remedy is close to curing, right? So would it be a removal of that impairment on the person's life if they were to undergo this treatment, or would it just help in terms of fluctuation, things like that? That to me is always the key question. You really want to outline the reasons why you consider it wouldn't remedy the impairment, and you go from there. So, is there any questions about the impairments? And I know that's sometimes a difficult one to get your head around.
So we don't have any questions just yet, but I will keep checking.
Lovely. Start checking.
Thank you.
That's good. So the next one I want to go through, so this is only relevant to meeting the disability requirements, and that is that the applicant needs to establish that they have a substantially reduced functional capacity to undergo one or more of the following activities, which is identified as communication, social interaction, learning, mobility, self-care, and self-management. I'll go into the detail of what those kind of things mean in a second. The important things to keep in mind with this and also obtaining evidence, it is, number one, it only needs to be one. You don't have to meet all of those things. The other things is the assessment and the information you need to provide needs to be kind of looking at what a person can and can't do on a day-to-day basis, and an assessment of that across a broad range of tasks. The other thing to keep in mind is, in terms of what the NDIA, and if it was necessary, the tribunal was considering, that substantially reduced functional capacity assessment can only be determined based on impairments that have been found to be permanent. So again, that's why I think it's really important to really clearly classify how impairments have been formed, because if someone, say, has physical impairments that have been deemed permanent, but has some psychosocial impairments that haven't, when they come to this stage of the assessment, effectively there's a determination that needs to be made, which is saying, okay, what elements are due to the physical impairments and what elements are due to the psychosocial? If, for example, the psychosocial is also preventing some like communication or social interaction aspects, that kind of needs to be carved out in this assessment. So very complicated, but really important to really clearly differentiate so you can try and have the most clean kind of assessment at this stage. So in terms of what evidence you want, you really want to clearly set out what a person can and can't do in terms of day-to-day tasks. where a person requires some assistance to perform those kind of tasks, whether that be person-to-person assistance, assistive technology, or other kind of home ones which could be helpful. The other point is to say, even with assistance, what task can a person not do? There's a few things I want to note, which is when you're looking at day-to-day task assessment, it is kind of, yeah, you're looking at one day, but it's also good to consider the short and long-term functionality. So for example, people with like fatigue conditions, they may be able to perform one task in a day, and the effect of that is that they then cannot perform other day-to-day tasks that same day or week or even a month, depending on what that task was. So when you're obtaining evidence, it's really helpful to really clearly demonstrate what the long-term effect is. Even though it might look like a person is physically able to do a task, there's obviously other factors that are prohibiting that, whether it be, like I said, fatigue, pain, or they're having to restrict bodily movement to avoid injury, and things like that. So usually functional capacity assessment report by an OT is kind of the gold standard. I always consider it's a really good idea to provide a statement, the applicant provide a statement. And the reason I say that is OT only comes in for a few hours, does an assessment and leaves. You're there, you're living your life every day. So if you can really outline like what a month or a fortnight of your life looks like, that's really compelling evidence. So these are the capacity activities. This comes from, again, this comes from the occupation, so the access guidelines from the NDIA. So this is broadly the kind of tasks that forms an activity. So importantly here, case law kind of has reflected that it's not as set in stone as this, like certain tasks can kind of fall across multiple ones, but these are kind of generally the types of tasks that you kind of need to make sure that you're responding to in terms of what someone can't do or needs assistance with or otherwise. The other thing to keep in mind is under each kind of activity heading, it won't be sufficient if only one activity can't be, one task can't be performed in activity. So when we're looking at like self-care, for example, if a person can do personal hygiene, grooming, eating, drinking, and sorting their health and bathing process by themselves, but they cannot toilet independently or need catheters, that, even though it's a huge part of your self-care is being able to toilet, that alone is not sufficient to meet that self-care, and that is a significantly reduced functional capacity. And that comes from a federal court case from a couple of years ago. So yeah, broad looking at multiple tasks is always the best approach. In terms of early intervention requirements, I will say that the majority of adults will gain access through the disability requirements, but you still can get access through early intervention. The focus of early intervention is the idea that providing supports early on will then limit needs for supports into the future. So when you're obtaining evidence or providing evidence for early intervention, you want to kind of identify what are the supports that are needed and how those would be beneficial for the applicant. And that includes, would it reduce the needs for supports in the future? Will it reduce the impact of a person's capability of undertaking those day-to-day activities? Will it help the informal supports to continue to provide informal support? And would it, overall help them build in functional capacity? The idea is essentially the NDIS has this process so that people can get the supports they need at an early age, often the children thing, so that they don't need those supports in the future and that they're set up for success in the future. So
we have questions.
I would love to have a look and we can move on to funding.
Okay, the first question is, how does the NDIS define psychosocial?
So psychosocial is very essentially. What I'll say is that psychosocial disabilities are a complex one. Typically, you'd have a look at if someone has a psychiatric condition, which is affecting their function day to day, that effect on function together is what forms the psychosocial impairment. It's atypical to the other ones in that way, is that there is that focus on how's that condition altogether kind of forming that psychosocial, but yeah, it's the direct link between the functional capacity effect and psychiatric conditions that someone has. I think that answers the question.
Thank you. Okay, next one. We've got a comment. I understand that to add another impairment, the new impairment needs to also meet the access criteria. How does one do this? Yeah. Do they need to submit a new access request or apply for a plan review?
I will get into this a little bit in a second. What I would say is there's changes to the NDIS Act, which it impacts the way that that can be done. I will go to that later. In terms of getting it in there right now, your options are to try and do a change of circumstance while impairment notices aren't a thing. If you're in a supports review process, you can try and do it through that avenue as well, and I'll get into why. But yeah, it's not a direct path at the moment, but they are moving towards a way where you can directly request an impairment be assessed as to whether or not it meets disability or early intervention requirements.
Okay, a couple more. Okay, in terms of the applicant writing a statement, I work with a lot of parents seeking NDIS support for their children. So would a carer impact statement also be beneficial?
Yes, completely. When you're looking at parents ones, I usually say, and this is because I think also for access and also trying to get funding for support, it is again doing that statement, but also having a record of, again, a fortnight of how often are you providing support, what are the incidents that may be happening, and really detailing like how frequently you're having to provide support to that person, because that helps to indicate, again, how why the benefit may be there for an early intervention support, and how that could be potentially getting that at this stage could help reduce that need for support. And then in the when you're trying to get funding for supports, and I'll go into this a bit more in a second, that can also help show why that need is substantially higher than a child of a similar age.
Okay, one more. Further to my question before about adding an impairment, is it necessary to add an impairment for a support to be funded?
I'll get into that very shortly.
Okay, all right, we'll hold that over. So that's it for questions now. We'll have to move on to the next. Yep.
Okay, so at the moment, the way to get supports funded in an NDIS plan is to meet the reasonable and necessary criteria, which is provided in the Act. I'll note that this is what's called an old framework plan, and we are shortly, the NDIA wants to move into new framework plans this year, and I'll get into that a bit at the end of the session. But for right now, this is the criteria you need to meet. I've just provided like a plain word approach, but essentially supports need to relate to an access impairment, need to help pursue goals, engage in social participation, need to be value for money. That's okay. Be effective and beneficial for them, take account of what's reasonable, expect informal supports and families to provide, and that the support is an NDIS support. What I'll say is for each support that that a person is trying to get funded in their plan, the reasonable necessary criteria has to be met, and that includes the level of support you're seeking, right? So if it's 5 hours, you need to establish that's reasonable necessary. If it's 10 hours, you need to establish that's reasonable necessary. So this is sometimes quite difficult, but hopefully we'll get into some information that will be helpful. The key ones that are issues are obviously the that it needs to relate to the impairment. The value for money one is also a big one. Reasonable informal support, particularly for children, is a big one, and also that NDIS support one because it's relatively new. I'll also say I don't have capacity to go through kind of SDA, so specialist disability accommodation today, but I'll say there is another requirement on top of this that it needs to be managed, and it's quite high in terms of the level of support someone needs to be able to access SDA. I can provide some information in some paperwork, but otherwise I'd say if there's an SDA issue, try and get some assistance from a legal provider to kind of talk you through that because it's quite complex. Okay, so hopefully this answers that last question. So the first criteria, and this is a new one that has been introduced within changes to the Act in October 2024, is that the support that you're seeking to have funded, or the participants seeking to have funded, must be necessary to address the needs of a participant which arise from an impairment, which means either the disability or early intervention requirements. So my view is that there's two kind of ways this can be done. The first one, which I think is the easiest, is that the support is necessary to address the needs for that accepted impairment. So the access impairment, the impairment that the agency considers does meet that disability or early intervention requirements. So with this one, very recent federal court law, and this, which helps very much clearly say how this should be applied, provides that what is needed in terms of meeting that is, as long as there is a causal relationship between that access impairment and the support you're seeking, it is okay that additional impairments or additional third party like factors are also resulting in that support being needed. The only time where option 2 might be necessary is if that support you're seeking isn't required because of the accepted impairment. So that, for example, could be someone gains access for physical disabilities, but they're trying to get funding for psychosocial impairments. That's a very clear one where it's hard to find that link that you'd be able to say it's arising because of the physical impairment. Because they would, NDIA and tribunal would consider it as a new impairment, although related to the condition in it, but it would be new impairment. But when that happens, option 2 is kind of where you want to look at. And the way that is done is essentially you need to establish that that additional impairment meets either the disability or early intervention requirements. So this is effectively a mini access case inside of a supports case that the NDIA don't really like doing, but legally you can do, and you can seek additional impairments during that process. And that's because of the wording of this requirement in that section 34(1)AA very clearly says either disability or intervention requirements. It doesn't say access impairment. So there is room to consider additional impairments when you're doing support funding. Again, if you're going down that path, you need to provide all the information that the impairment's permanent. You need to establish that it's going to either need early intervention or would be a substantially reduced functional capacity and those requirements. So something to keep in mind. Definitely easier to say or to try and get that link from what you've already gained access for and say the other factors are just contributing to it. So this is another big one that gets hung up a lot in terms of support getting funded. When you're looking at value for money, it's often kind of looked at as what's the cheapest support that can be funded. In reality, value for money is an assessment of benefits and outcomes versus cost. So what you're kind of wanting to really focus on in terms of getting evidence and providing evidence is what is the benefit that this support would provide the participant, and that is what are the outcomes for their functional capacity, need for future supports, their well-being, to reduce any kind of risk. That is really important focus there, because that's what justifies the cost of the support. Where you're trying to increase support funding, right? So you're going, say you have 5 hours of support work per week and you're trying to get 10, you want to consider what the current outcomes are of that level of funding, why it's not sufficient, and how would that increased funding help to, again, reduce functional capacity, or why is it needed to obtain benefits at this time. Similarly, with increased capacity building supports and that, the real focus is what's the benefits, what are the outcomes, are there any other supports that could obtain that for the same, for a substantially lower cost? If not, then hopefully, you've got enough evidence to say it's value for money. The other part I'll say is, in terms of assistive technology and consumables, you really want a cost analysis in evidence in terms of this is the cheapest, most effective model of XYZ thing. So those are kind of a few things to keep in mind. Being mindful of time.
We've got plenty of time.
So this is, what I'll say is, when assessing what is reasonable to expect families and informal supports to provide, yes, there's the criteria in the Act that doesn't really go into the difference between child and adult. In the rules, there's a very clear difference between what's being looked at between children and adults. So most often I'll see this being an issue with children, particularly when you're trying to get increased support worker assistance and things like that. What the rules kind of identify is, first and foremost, is that for a child under the age of 18, it's very normal for parents or guardians to provide substantial care for that child. So in order to get funding supported, you really need to clearly set out that what these supports are needed because it's above what you would reasonably expect a parent to provide their child. The way you do that is, first of all, you need to establish that the support and care needs for that child are substantially higher than other children of a similar age. So there's really that comparative of what kind of level of support would you expect a child needing at a certain age in their life. Obviously, if a child is 3, that's quite a high standard that parents will be providing that support. But when your child is 16, you wouldn't typically expect them to need 24-hour supervision. So those are the kind of factors you're trying to think about when you're kind of establishing that aspect of it. The next part is, would funding the support you're seeking, is it necessary to minimize risks to the well-being of the participant's family, carers, and others? So that is an aspect where it's important to look at how is the needs for supports or the functional capacity issues, how is that impacting the people around the participant as well. The other factor is, would funding the support at the moment, would that help to increase their current functional capacity or their future current capacity? So future functional capacity. So you see that a lot with trying to get increased capacity building supports or for older children where having a support worker actually assist them to do these tasks would help them increase their independence into the future. Also, you want to have a look at what are the risks to the participant's well-being if the support isn't funded, and that can be when you have sometimes behaviours of concern. Is a support worker or a secondary person in the house necessary to ensure that everyone's safe, and including the participant? In terms of that carer burnout factor, it's really helpful to have that documented, and if there is any evidence of additional things that would impact that, that's also helpful information, because those factors should be considered by the agency to ensure that the family is supported sufficiently, and especially where that need is coming from their disability. I have a note at the bottom of this, which is that the NDIS won't fund childcare costs. They won't fund out-of-school care costs, including vacation care. They won't fund school refusal programs. It's very unlikely that the agency will fund transport costs or support workers to take participants to appointments, or support workers during typical hours. The reason that this is that it either falls into what you'd reasonably expect a parent to provide, or is something that should be the responsibility of like the education department to respond to, or reasonable accommodation. Okay, so for adults, yeah, I typically see this one come up as an issue with parents with adult children who have disabilities. But it also can be considered any criteria. It's still a criteria for everyone, but another one that comes up for issues is if you do have a shared care aspect at home, like if you're needing help assistance with cooking and cleaning, there is an aspect to consider. Well, you've got a partner at home, they should also be contributing to that. So this can come up sometimes as well with that. Essentially, and I think this really does mostly apply to that consideration of parent with adult child. Especially I see it a lot with parents who are trying to get their child into like a SILS or supported independent living and out of the home. The evidence you really need to provide is what are the risks of the participant that come up because they are relying on that informal support. That could be, obviously, with that informal support, reduce their independence or building of independence. Does the person who's providing the informal support actually have the capacity to provide that support? So again, back to adult children, often these parents are aging into their 60s, 70s, maybe later. Do they realistically have the capacity to be providing that level of independent or informal support that person requires? So really clearly setting out what are the dynamics at home, what are the limitations that the informal support has, and also those aspects of making sure that they're, as a 20-something, 30-something-year-old, should be allowed to live independently of their parents as well, because that's a kind of normal expectation. I'll note as well in terms of age and gender aspects, obviously there are some supports which are quite sensitive, and you do want a specific age or gender to provide that. There's also considerations in terms of children providing support to their parents. It shouldn't be expected that children will do that, particularly if it's impacting their life elsewhere, like obtaining education or employment. So those are a bunch of different factors to consider there. So the kind of last big one I want to talk about in terms of support funding is NDIS supports. So this is relatively new in the last 2 years or so. Essentially, whether or not a support is or is not NDIS support comes from currently some transitional rules that have been published. The way those rules work is there is a Schedule 1, which outlines what supports and the category of supports are NDIS supports. And then there's Schedule 2, which outlines which supports are generally not NDIS supports. The NDIS also has some operational guidelines, which also provides this information, not in an ugly legislative format, so you can look at those as well. So what the case law says, and the way that this applies, is if you're wondering if a support is or is not an NDIS support, the first step is to look at the list of what is not an NDIS support. If what you're seeking falls into a not NDIS support, it can't be funded because it doesn't satisfy Section 34(1)(f), which is the support NDIS support essentially. And there's no wiggle room kind of around that. But essentially, if it's not, it's not, and that is the end of the story. If it's not included in that not NDIS support list, right? The next step is to find it, is it included in the NDIS support lists? If it's not in that list, then it again is not an NDIS support. If it is, well then yes, it's an NDIS support, but you still need to meet the rest of the reasonable and necessary criteria for that support. The main thing I want to get away here is if it's not an NDIS support, it just can't be funded. And the thing to try and keep in mind, and I think I'll go into this a little bit in a second, is even though it might not be specifically stated, if it falls into kind of the categories which are provided in those, it likely will be considered non-NDIS support. So, onto the next bit. These are kind of the common ones I see come up that are not NDIS supports. And I say it's a really good idea to try and get your head around generally what are not NDIS support, especially people who are providing recommendations for supports. I often see a bit of confusion and frustration from participants who are saying, but I've been recommended this. And it's like, I understand that, but it's not something that they can get funded. There used to be a carve out before these changes. That carve out doesn't exist anymore, so non-NDIS support cannot be funded. So common things are standard commercially available household items, appliances, fixtures, and furniture. So if it hasn't been modified to meet that person's need or it's on assistive technology, it can't be considered an NDIS support. Previously, there was some ability to get a portion of increased expenses in relation to running medical equipment funded, so like the additional electricity. That can no longer occur. A big one is noise cancelling headphones. Those cannot be funded because they're not considered NDIS support anymore. Another big one is kind of standard footwear and clothing. That often comes up with like orthopedics, people who require those. The orthopedic can be funded, but the actual shoe itself cannot be funded. Similarly with clothing, so things like clothing that's commercially available, such as like period underwear that a child may need, that's something that is not something that can be funded because it is typically considered standard in that it's commercially available. The other big one I see as well is when the support is clinical in nature or rehabilitative in nature. I'll go into a little bit more detail in a second. So if you're trying to provide evidence that a support is an NDIS support, this one can be particularly difficult because of how strict it is. When you're looking at that day-to-day kind of question, you really need to clearly establish with evidence that what you're recommending isn't a standard commercially available item. So that means detailing how it's modified or adapted for individuals' functional needs, or why it's specifically an assistive technology that's being recommended. In terms of that clinical health and mental health treatment or rehabilitation aspect, what you're looking to kind of make sure it's very clear in the evidence is the nature of what's being recommended and how it would be provided. So, for example, obviously physiotherapy can be an ongoing therapeutic support for someone, but it also can be rehabilitative in nature. The main difference I like to look at is what's the duration that's being recommended that this person obtain. If it is a short time limited, like a 3-month physiotherapy recommendation, that to me would fall into a clinical treatment and rehab, not a ongoing therapeutic support to build functional capacity. So you really, really clearly want to kind of identify those factors around it and to show what is the purpose of it. Is it a clinical treatment? Is it post-injury, or is it for that ongoing functional capacity maintenance and improvement?
Questions? We have more.
Lovely, happy to answer them.
Okay,
I was going to say we can go. I've only got changes afterwards if you want.
Okay, yeah, I'll just see what we've got. Okay, sorry, I'm just scrolling through here. Would love some information around SDA funding for clients with legacy SDA option in their plans.
Mm-hmm.
Sorry,
Mid-water. What I would say is it is quite complex.
Mm-hmm.
I would typically, and like I said, I can provide the general criteria information, but it really is individual, person by person, based on the information and evidence. So in most cases, I would say reach out to your states or regional kind of legal aid and ask, see if you can get some advice with one of the lawyers. Mm-hmm. That's probably kind of the best starting point because it is so individualized and it is quite complex.
Okay. We may have covered this already. Can you explain attribution when it comes to impairments?
The way I would say it is that you need to look at the way that the NDIS has defined impairments. And then realistically, you want a clinical treatment provider or a specialist to have a look at the way in which a condition affects someone and obtain evidence from them as to how they would categorize it. That is probably, I would say, the best approach, because obviously I'm not a doctor, so it's not something that for an individual you could really specify. But I think having a treatment look through how it's affecting you with the lens of this is how the NDIS is defining it is probably the best approach.
Okay. In terms of supports for children, what if the parent has disabilities of their own? Does that count as a reason to ask for additional support over and beyond usual parental responsibility?
So, where you have households where parents and children have disabilities, there's a few things to consider. Where a parent also has an NDIS plan is also a participant. Sometimes what you want to do and what the agency can do is have a look at everyone's plans together and say, okay, where is it most appropriate that this funding gets put into the plan? Things like, obviously that transport question, it's not something that can get funded in the child's plan, but if the parent needs assistance to ensure that they're meeting their obligations as a parent in terms of their disability is limiting their ability to ensure that they're doing those day-to-day tasks or transporting or things like that, then there might be an avenue for that kind of funding to be put into the parent's plan. So if they both have disabilities, both on the scheme, I always say it's good to have a look at it holistically and try and work with the NDIA to see where funding can go to ensure that the family unit is well functioned and make sure they're supported enough. Where a parent doesn't have access to the scheme, it's more difficult in the sense that, yes, you can identify that these are limiting factors and there is that need for ensuring that the child support needs are met, but ultimately there are limits to what the NDIS will fund. If a parent is, because their disability is unable to kind of meet what you would typically expect a parent to be able to provide, and they're not on the scheme, there's limited things that the NDI can do to really overcome what would be that reasonable necessary funding criteria, right? So ultimately they would also kind of consider, well, that's the responsibility of either healthcare, then the person needs more treatment, or even in some stages like family services to ensure that the child's getting their needs met. It's not a good answer, but I think that's ultimately where it falls.
Okay, we're going to do a couple more and then we'll continue on with the content. I'm just looking at the time, but if we do need to go over by 5 minutes to answer your questions, if you have to leave early, that's fine. Just know all the questions will be answered and will be included in the webinar recording if you want to go back after this webinar to take a look. Okay, so I'll just put one more question to you for now. So continuing on from that question, like for example, support coordination funding for a child whose parent has an intellectual disability and they need assistance to manage their child's NDIS plan. Yeah. I think that would typically, if there is a need for the child to have assistance to ensure that the plan is being used, then there might be an avenue then to say, yes, support coordination should be funded. It, I think, is also an individual case-by-case circumstance where you'd have to really look at what level of functioning capacity that parent has, who's the decision maker in the family. Obviously, people with disabilities can be the decision maker, but obviously sometimes they're not. So there's a few different aspects there. I will always say, try the argument and see what happens. But I don't think there's any guarantee that would inherently provide funding, but there is an emphasis to ensure that informal supports are being supported to ensure that. So I think it's worth pointing out and saying, look, this is why that is needed in terms of support coordination. Okay, we'll hold questions there. We'll go back to the content, but we will answer the remaining questions at the end. There's not much left to go. I just want to briefly go over the changes. So I've kind of mentioned a few things throughout this thing, but I thought it'd be best to put this at the end.
October 2024, the NDIS Act was changed following passing of an Amendment Act, essentially. There's a few changes that resulted in terms of the main kind of factors that are impacting participants and applicants. The first kind of shift is this shift from old framework plans, which is that reasonable and necessary criteria, into a new framework plan, which I'll get into in a second. Thing to keep in mind in terms of this change in the old framework plan is that inclusion of the support needing to be related to the impairment, and that the support must be an NDIS support. Those are the two main changes there. The other thing here is in terms of how reasonable necessary supports are funded, is that each individual support is being assessed as to whether or not it's reasonable or necessary. And each individual support it has to meet a specific criteria. So where we're going is moving on to the new framework plans. So what the agency is saying, and unfortunately it's not much information I can say with confidence because it's not been much provided, but so far what the agency is saying is that they're looking to transition into the new framework plans from mid-2026. There's been some public consultations recently which had a look at writing some rules to help inform how the legislation works. Unfortunately, with that consultation, they didn't provide any draft rules. So again, it's still up in the air. But effectively, the way it looks like it will work is that instead of assessing individual supports as whether or not they're going to meet that reasonableness criteria, the assessment is now going to be done on a whole person assessment of need, with a budget being assessed as what's reasonable and necessary. That planning decision will be based on what's going to be called a support to need assessment, which helps inform what the reasonableness budget will be, and also that new kind of looking at what the impairments are, which are listed in the notice of impairment. So the notice of impairment, some people have already started getting them. That was also a new change. What that has will classify what impairment the NDIS considers you've met access for, whether or not it's been from disability or early intervention requirements. There's also some mechanisms that you can do with that to request a variation of that notice, which is a new thing, and it's actually really good. It helps clarify whether there are additional impairments, so you can go through that process. But that is less of an issue in terms of this is really unclear still. We don't know how it's going to play out. And it's very much kind of a watch this space, which is not a comfortable thing for people who rely on NDIS supports for to function every day effectively. I would say that you can subscribe to like the NDIS updates, and I can put a link to that in the additional materials. They will usually send out an email with like recent updates and things that are happening. That's how I keep informed, and I think it's good to keep your head around, especially as these changes are rolling out. And look, yeah, we'll see how we go. It's not very clear who's going to be doing these assessments or anything like that. So unfortunately, it's about all the information I have on that issue. How can we help? So effectively, the way that Queensland's legal aid system team works, it might be different for other legal aids in the country, but the way we work is that the NDIS appeal lawyers, we can provide one-off advice to participants and applicants for access. They can have more than one-off advice essentially. So you can have an advice, and then if you need some help later on, you can book in again. They can book in again. And we'll usually provide advice on most issues in relation to NDIS for either a participant or applicant, regardless of if they've gone to the tribunal or not, because it's a confusing process all around. If you need representation, that typically can only be obtained if there is already an external review in the tribunal happening, and you also have to apply. They also have to apply for a grant of legal aid and be accepted for representation as well. So that's the kind of two main avenues that we here can do. I will say that I believe each state Legal Aid has their own NDIS team, so I'd say definitely reach out to them if you need some advice. And there's also disability advocates across Australia who do provide specific NDIS assistance and support and advice as well. I can provide some more information in the step. And that's it.
All right, so we've got a little bit of time for questions. It is 1 o'clock, but we'll go through what we've got here because we want to make sure we get more answers. So I'll just bring those up. Okay, we've got 2 sitting here. So in relation to some earlier content you covered about supports, what if there is a vacation care facility that specialises in disability-specific care for young people, as in only take children with diagnosed disabilities, and their service helps to improve functional capacity through the activities they engage children in? Would that be funded?
It would depend on the service and why there is a need for that vacation care service. My gut instinct says no, because the NDIS support rules really clearly, in terms of non-NDIS support, says vacation care. So if it's going to fall into that, I would say no. There is a reasonable question in terms of that, is if that would actually be considered a community engagement group potentially. So that might be something that gets funded, but I think that then would fall in the question of, could that child be attending a mainstream vacation care with reasonable accommodations, or do they need to go to this disability-specific vacation care? Again, unfortunately, individualised. I think if there's any confusion, I always recommend chat with, if you have one, a support coordinator or the LAC, or contact the NDI directly, or get some legal advice.
Great. The other question is, was there a recent case where someone got a support from the no list? I think it was a doorbell due to blindness.
I haven't seen that, but I can definitely look it up, and if it's in there, I can respond to that. Consistently, the cases I have seen have been, if it's a no, then it's a no, and that's across multiple tribunal members as well. But I'm happy to look it up and provide an update if that's the case. Hopefully it is.
That's it so far for questions. So what I'll do is, you've still got time to ask 1 or 2 more questions. I'll just wrap up with a tiny bit of extra information, and I'll come back and check if there's any more questions before we log off. So just a couple more slides to go through. These are the standard legal aid phone numbers to call if you have a client needing legal help. So the first one there, our 1300 65 11 88, that's our standard phone line to call if you're wanting to access services like our NDIS lawyers and looking for advice. The second number there, our Aboriginal and Torres Strait Islander information line, that's a priority phone line. We answer those calls quickly in the call queue. So if you do have a First Nations client, we encourage you to use that phone number. And the last number listed there is for people who already have an application submitted for legal aid and are wanting to check the status of that.
I will mention quickly that there is the normal legal aid application form, but if you're also applying for an NDIS appeals representation, there are a consent form and an additional form that needs to be filled out.
Okay.
Also, that the grants assessment for NDIS matters is not means tested, it's only merits tested.
Okay.
So regardless of financial standing, you can still be assessed and potentially get granted.
We could include links to those consent
in the email
I can provide after this.
Yep.
So just a reminder that the legal aid website, it has a wealth of free legal information on it about a whole range of different legal issues your clients may be experiencing. We also have like over 80 free legal information publications on there that can be downloaded, can be printed. You can also order them for free and have them delivered to your organisation for free. So please get on there and take advantage of that great resource. It's all free. The last slide here is just a reminder to keep registering for our webinars next month. The topic is just being finalised. It will be focusing on how Legal Aid Queensland helps people who've separated from their partner partner, and we'll be running through our mediation, dispute resolution services, property settlement, child arrangements, and also we'll be talking about our referral pathways for legal help. So please look out for that one. It will be held on the 30th of April and registration will open soon. I'll just go back to the questions tab just to check if any other questions have been submitted before we wrap up. No, that's it. So we'll call that time now. So thank you so much, Lana, for making yourself available. That was a lot of in-depth, detailed content, but very helpful to everybody. And yes, so please everyone look out for the email about the recording. There'll be a handout, there'll be lots of extra information, links from Lana. So hopefully we'll get that out by the end of the week. But thank you so much for attending and hope to see you at the next one.